recording this case. Okay, and we are live and recording. So, Your Honor, we have counsel for both parties here on Espinola versus Murphy, which is 2023 J637.
Hi, folks. Good afternoon. This is an appeal bond hearing. You both, I'm sure, are familiar with the rules here, which I will just briefly state, which are that I have to hold this by statute. We are not discussing or deciding the merits of the appeal. The appellant, Ms. Espinola, has to show two things: that she's indigent and that she has a non-frivolous issue for appeal in order to waive the appeal bond. Mr. McCardle, do I recognize you from Monday, sir?
Yes, I know you were enjoyed that post judgment appeal of that settlement agreement issue that we had a nice dialogue on Monday. Yes,
Thought I recognized you. And Mr. Eaton, you represent the Murphys, or you represent Espinola?
Espinola.
So you represent the landowner
That's correct.
who bought out of foreclosure, is that right?
That's correct.
Okay. Well, it's your petition, Mr. McCardle, so why don't you start?
sure. Regarding the two elements, the non-frivolous aspect of the appeal, I know the bond was only issued at 200, so it's not a huge issue to have to pay a $200 bond, but I still think it was an incorrect application of the frivolous standard that I set forth in my petition. It would be an insult to my intelligence to some degree to suggest that the appeal that I put together was frivolous in nature. And I don't think my brother would sit up here and tell you anything otherwise if he was being honest with you. It's a 30-page motion that's comprehensive, 100 pages of exhibits. It's thorough, and honestly, I expected to win on that summary judgment motion with the strict compliance issue that's set forth within. And
Which issue is that? Strict compliance with 22?
With paragraph 22, that's the simplest
But
application.
they say in their opposition they did strictly comply with 22. What's
No,
your issue fact on that?
They absolutely did not. There wasn't even a notice sent to one of the mortgagors at his correct address. So it's that alone makes it non-strictly compliant. He didn't get proper notice. Second of all, the history of this is, I implore you to take a moment to just read Exhibit B, at least the statement of facts of the summary judgment motion. I know you're not making a determination on the merits of the case, but the merits of the case are one of the elements of the King factors when you assess the bond. If you look at the merits of the case and you determine that this is meritorious, or that you feel like this is a strong issue for appeal, that's supposed to be one of the elements for the determination of what the use and occupancy amount should be. And if you just take a moment to read just the statement of facts, you'll see that this has a rich history. This stems back to 2010. There was a divorce decree with my client and her ex-husband. She was supposed to get the property deeded to her. The husband never deeded it to her, so she was supposed to refinance, but she couldn't because he never deeded it to her properly. And unbeknownst to her, he started getting the mortgage statements sent to him at his separate address, because he was the only one on the note. She was an obligor on the mortgage. They both were. He was the only one on the note. So the servicer was only dealing with him. He was supposed to continue paying the mortgage until their son turned 16 or graduated from high school. He stopped doing that unbeknownst to her. So when she tried to refinance, she had a default on her record. She couldn't do it. She tried to modify. They wouldn't modify the loan because they said she wasn't a borrower on the note, even though she was a borrower on the mortgage pursuant to Chapter 244, Section 35, which is the new requirement to attempt to modify a loan. So there's a rich history. So they went in and foreclosed on this. When the note, there was only $80,000.
Of course, she's been paying use and occupancy since she found all this out, right?
No, she only
she's been in the house for free for I don't know how long.
Sure, but she only owed $80,000,
right?
She owed $80,000 on this loan. This was a $1,300 payment. She could have easily made this if they just allowed her to get back into good standing. There was an unlawful foreclosure already on this very loan in 2012. We already went through this and got the first foreclosure thrown out So there was a 5-year period where she wasn't the owner of this property because of this unlawful foreclosure. They actually sent the renewed default notice to her before she even was revived as the title holder. There was a 5-year period where she wasn't the owner of the property, and they assessed all of the real estate taxes and interest and late penalties on top of the loan, and then just said, hey, oh, sorry, we did an unlawful foreclosure 5 years later. We're going to dump you with this and all these fees, all the taxes, all the real estate
Did she
taxes.
remain in the home during that period? When did she move out?
She was in the home for a long time, but when we talk about the home going into a state of disrepair is because she didn't own it. She wasn't going to fix it. She didn't know what was going to happen with this. She didn't own it. She wasn't the record holder. So this is a long period of time where she was just sitting there waiting for this to be resolved. All she wanted was this home to be back and to pay off this loan. She built this house. But she's been living in Florida of late and working temporarily in a school down there until this was resolved, because she was working in a school up here prior to, and anticipates coming back. But she's a school teacher making $30,000 a year. So the suggestion that her
Right, so
affidavit
she's
is
making $30,000 a year. So how does she qualify as indigent?
under Section C is the only reason she qualifies as indigent, because they sought a $200,000 bond or something of the sort. So under Section C, if you can't afford the cost of the bond, and then you're automatically considered indigent, and that's why the judge did determine that she was indigent. So that wasn't the aspect.
Yeah, he did, but I'm having trouble with a $200 bond finding that she's indigent in order to waive the appeal bond.
Right. If there's $200, she can afford it. She's not indigent under the $200.
Well, they haven't cross-appealed. They're not asking for a larger appeal bond, are they?
Yeah,
Are you asking for a larger appeal bond, Mr. Eaton?
We did in the original motion, Your Honor, per the statute of 239, Section 6.
But then on this appeal to me about whether the appeal bond should be waived, you haven't cross-appealed, right?
I have not, Your Honor, no.
Okay, so you do not have before me a request to increase the amount of the appeal bond. The appeal bond's $200.
That's correct. Your Honor.
205, something like that.
Yep.
Okay.
Yeah, so I agree. It's kind of an exercise of futility regarding the bond at this point. The argument was regarding what they asked for originally regarding the larger bond. So yeah, now that it's $200, that the affidavit doesn't mean as much, obviously, because it's only $200, and she's not indigent pursuant to a $200 bond. So it's more about the use and occupancy pending appeal going forward.
What have you argued to me about use and occupancy?
What's that? Sorry?
What is your argument about use and occupancy?
Well, the use and occupancy assessed is $2,500 a month, and it's supposed to be an overall assessment of the circumstances under King regarding the value of the property, which it's unrentable. No one can live there, so the market value of rental it's zero. Maybe the value could be the carrying cost of taxes.
Didn't the judge find otherwise?
Yeah, well, it was kind of an arbitrary determination of $2,500, because that wasn't a number that anybody argued, but I'm not sure where.
I have a finding here. The fair rental value of the premises is $2,500 per month.
Yeah, I don't know what the determination was based on, because I think my brother provided a BPO or CMA that suggested $3,500 for comparable properties, but they're just compared to the size, the number of beds, the number of baths.
So he asked for 35 and he got 25. That's a finding by the judge. How am I going to overturn that?
Well, there's
what is your evidence that it's worth less than 2,500?
There's an affidavit from my client about the conditions. It's real.
Yeah, but that doesn't tell me a value. That just tells me in her view, it's not in very good repair.
Well, it's riddled with mold. It's uninhabitable.
That's what she says. The judge has a finding that it's worth 20. Mr. Eaton, what was your evidence as to the value of use and occupancy?
In the motion for an appeal bond, we included a rental analysis by a local broker who determined that the fair market rent at the time of the hearing was $3,550 per month for a single family residence in that area. That was attached to my motion for appeal bond.
And what are the taxes that you're paying on a monthly basis right now?
I don't know if they are on a monthly basis, but the 2003 tax bill was about $6,500. And there is a copy of that tax bill attached to my opposition.
So, Mr. McCardle, how do I get where you want me to get? Which
Well,
is,
the other-
what do you think is a reasonable use in occupancy? Less than the taxes that someone else is paying?
No. I agree. I think the carrying cost is relatively fair. Like the taxes and insurance costs on a monthly basis, that's fair to have to cover those costs. I think that's skin in the game that my client should be agreeable to, even though she doesn't possess the property, which I think the other aspect of my petition,
Let's pause on that for a moment. She doesn't possess the property, so you're willing to give up possession?
she's already given up possession of the property. She doesn't live there.
Okay, so the bank can have it.
It's not a bank, but yeah, the purchaser at the auction can, yeah, he can take, sure. Right now, possession she's vacated the property.
Well, then what are we arguing about? I'm
Well,
having trouble.
that's part of my argument is that under the Demas Jeans decision on the appeals court, there's two elements to having to implement a use and occupancy. The plaintiff prevails and the appealing party defendant remains in possession of the property.
Yeah,
which
I
she
read
does
that
not.
case. I don't think so. But this is a action for summary process. If she concedes possession to the plaintiff, what are we arguing about?
She concedes possession of the property to the plaintiffs as long as she can exercise her rights of appeal, sure.
Her rights to appeal where she's going to regain possession.
Potentially, if she's
Well, then she
successful.
hasn't conceded possession, Mr. McCardle. She hasn't conceded possession. She wants to retain possession.
Well, she wants to retain title. I mean, obviously possessory rights come with title, sure.
Yeah, that I was having trouble dividing the two as I'm sitting here.
It's an odd predicament. I understand.
I don't think your client concedes possession. I think your client possesses the property because your client doesn't concede that the plaintiff may take possession of the property
Sure.
permanently.
Sure. So accepting that that we're conceding that she's still seeking title and seeking rights to possession, and there's got to be at least some type of concession regarding her not having actual possession, and because use and occupancy is the value of use and occupying the property. She can't use and occupy the property because of the condition.
I mean,
of
if
the
she was
property.
renting the property, you couldn't make this argument. You're just making this argument because your evidence is she's not in it. She's in Florida.
Well,
She's chosen not to upkeep the property since she got it back. I understand that point. When did she get it back?
From the foreclosure,
Yeah.
it was 2017-ish, around that time.
So for the last 6 years, when she could have lived there, she's chosen not to spend money on
I think she spent some time there. Certainly, her children live in Florida, so she's moved down there temporarily with them until this has been resolved. But she wants this. I mean, she wants her property. This is her home. She literally built this and let it go into disrepair because of it's. I implore you to read the facts of this case. It's more than meets the eye.
Yeah, I have a sense of what you're saying. You do understand my concern, which is I don't think people should be able to retain possession of a property without paying for it for what is now, I don't know how long it is. It's over a decade. I have a problem with that.
I understand.
And that's what use and occupancy in the King case are all about. And you say, well, 2,500 is unfair because you have to accept that it's uninhabitable.
Well, it's also unfair because she can't afford that.
That is not.
That's part of the application.
That is not a factor in King.
It is. I promise you, it is.
Her ability to afford use and occupancy?
Yes.
It certainly wouldn't be if this was a tenancy.
Well, King is certainly addressing more of a post foreclosure matter, but these are the factors in King are the value, the fair market rental value, which is not 2,500. The merits. I'm a licensed broker. The merits of the defense, the amount owed per month on the mortgage, the number of months that no money has been paid, the real estate taxes, the expected duration, and the respective financial conditions of the parties. It's a factor. It's an express factor in King. I think the merit, Your Honor, I think the merits of the case are one of the most important factors. She should win this appeal. Like this decision by the housing court didn't even provide one finding of fact or ruling of law on a 30-page summary judgment motion. It was an insult
Let's
to
assume she wins the appeal.
Mhm.
So what does that mean? That means that Mr. Espinola is out of luck. He can't take possession, even though he's the mortgage holder.
He's not the mortgage holder. He's a third party auction purchaser.
Okay.
But he would be able to get relief from the entity who performed the unlawful foreclosure. They would have to make him whole.
So that entity's out of luck. Their mortgage was no good.
That entity is certainly out of luck. Yeah. No, their mortgage is good. They just have to redo their documents and do a proper foreclosure. If you look at it, they didn't even revive the mortgage and revive her as title holder before they sent a default notice that
They weren't being paid. The mortgage was in default.
It wasn't in default for 5 years because it was foreclosed and no longer existed.
But before that, they weren't being paid, and the mortgage was in default. And
it was
somehow,
in default
out of this process,
it was unbeknownst to her, though, Your Honor. Like, you got to understand.
I hear that, but I don't. I struggle to have sympathy for that. She was married to the guy, right? She was in the middle of a divorce proceeding. So
Right.
there were things that could have been done to figure out what was being done with her home. I don't know those issues, and I'm not in a position to really evaluate them. The only question is whether you have non-frivolous defenses and whether she's indigent. And as to that, I don't think she is for purposes of this appeal bond. Let me ask Mr. Eaton something. What do you say to what he says about what the use and occupancy should be? He says, reasonable to pay insurance and taxes, but this thing is unoccupiable. How do I get into that and think about that problem?
Well, even if it's unoccupiable, I
Well, do
think
you concede that it's unoccupiable?
I can't because I haven't been to the place. I don't know, and my client hasn't been in, and we've only been able to.
The affidavit, which I'll take a look at, but the affidavit which you submitted in connection with the request for use and occupancy that sets the value at $3,500. That's from a local broker?
That's correct.
Did that local broker take a look at the property?
Probably a drive-by.
Is it shown in the affidavit? Do you know?
It is not, no. So it could be just information gleaned from the records of.
Yeah, it looks just like a comparative market analysis where you just take record MLS listings and then just make a comparative market analysis. That's basically what it is.
So what do you say to his position that it's not worth $2,500 because nobody can get in it?
Well,
how do I resolve
the judge of the bond hearing took that into consideration by reducing the rent I asked for to $2,500. I mean, if use and occupancy
at the bond hearing, was there any further evidence presented other than the affidavit that you presented and the affidavit of Ms. Murphy?
No.
There wasn't any evidence taken, right?
No, the market analysis was uncontroverted, except by the affidavit of condition of the property. So the judge took that into consideration by reducing the monthly rent or use and occupancy required to $2,500. So he was aware of all.
What other costs does your client have to incur right now on a monthly basis besides real estate taxes and insurance?
I can't answer that, Your Honor. So I would have to say just insurance and real estate taxes at this time.
Do they have to heat the house?
I'm sure there are other carrying costs of at least, I don't know who's paying the electricity if there's anything there, or
yeah, electricity, heat.
He's not paying any of those things. I think she listed that on her affidavit that she was paying electric and certain other aspects of it. I'd have to pull it up, but I'm pretty sure she listed some of those utilities.
I'm looking for it right now. Hang on. Yeah, I don't see anything in here about her paying anything right now.
In the
She
affidavit?
avers in the affidavit it's not happening.
Oh, not her affidavit. I'm talking about her affidavit of indigency.
Sorry.
Yeah, I can pull that up
I
somewhere.
got it.
I think it says electricity, $450 a month, water, 103.
Oh, but we don't know whether that's for this property or for some property in Florida.
I guess so, but I don't think she's paying at her kid's place. But I obviously can't testify to any of those. But I can only assume that she's paying for that. I don't usually you don't put electric in your name unless you're occupying the property. Water, sometimes they force you to as the new owner, but
Okay. Seems to me the issue is use and occupancy. I need to think about that. Mr. Eaton, what have I missed?
I think that's your determination for use and occupancy. I think the merits of the defense issue are decided by two Northeast Housing Court justices after review of the proper.
Yeah, but the standard for non-frivolous is awfully low.
It is, yeah. But I mean, she
And-
hasn't paid anything since 2010 on the property at all.
Yeah, but does that go to her defenses?
Well, there was the
Or more accurately,
family
does that
court.
go to the fact that she hasn't paid? Does that go to the issues on appeal? The frivolous or non-frivolousness of the issues on appeal? That's the question, right?
Okay, so the real estate taxes are applicable. It does say the months no payment have been made under the King case. Here it is quite a while.
Good point.
The financial condition of the parties, if you review the affidavit, her arithmetic is incorrect, and she has about $1,900 of available funds to go towards a use and occupancy amount. And I think the Northeast Housing Court judge, in determining a $2,500 use and occupancy, took into account the affidavits and rental analysis and condition of the property. So I think something.
So if I were to look at those issues in King for setting use and occupancy, one of them is the length in which no payments have been made on the property, right?
That's correct.
But that's typically related to the relationship between a mortgagee and a mortgagor. This is a third party purchaser that her not paying in 2010 has nothing to do with this damage to this fella.
They got the third party. Well, okay, but the third party took possession when, or the third party won its foreclosure case when?
The summary judgment was in August of this year. The foreclosure sale itself was in 2018.
So they've had title for 5 years without receiving any payments at all and having to continue to pay taxes and insurance, Mr. McCardle.
Agreed. I think that's an element, certainly.
You think that factors into the judge's decision making as to what use and occupancy should be, right, under King?
Certainly. I think that's one of the factors, yes. One of the other factors is what was actually owed per month on the mortgage, which was only $1,300. One of the factors is the merits of the defense, which I think really needs to be looked at more clearly, because the way these housing court judges are providing orders on these summary judgment post foreclosure matters is becoming a bit concerning regarding real justice. It's overly concerning for someone who practices in this area of the law, and then imposing an order that prohibits them from appealing the judgment that this judge just put into place. It's like I said before, it's insult to my intelligence to suggest that the brief that I put together on this case is frivolous. It's the furthest thing from it, quite the opposite. So it's frustrating to even be here to have to argue this.
No, it's not. The reason I'm sorry, Mr. McCardle, it's not, because your client is under an obligation to pay use and occupancy regardless of how good your arguments are. in order to maintain her appeal. And you needed to come in and argue that. You needed to argue you could use an occupancy.
Sure. No, my
Always
point is that
insulting her.
my point is that I don't think I should be here because we should have won the judgment. That was my point. I wasn't trying to say I you know, anything otherwise. My point was that I should have had a favorable decision at summary judgment. At minimum, this should have been put down for a trial with the facts set forth in this case. And I'm very confident that this strict compliance issue, it's just simple application of strict compliance. I don't know where that's missed in this for the lower court judge, but that's why we're trying to get to an appeal. And I think it's unfair to prohibit somebody by imposing a use and occupancy that's beyond what she even makes on a monthly basis, never mind after bills. The way the housing court justices used to deal with this was they would come up with a fair use and occupancy and see what someone can afford, give them an opportunity if it wasn't frivolous, and make sure they had skin in the game and give them an opportunity to actually exercise their rights. It's changed, and they don't want to allow these folks to appeal these cases anymore, and it's discouraging. But I know you take a close
Even
look
if
at
what
this.
she needed to pay, even if what your client needed to pay was taxes and insurance on what she says is her house, she'd be struggling under the affidavit that she submitted.
Sure. To be probably $800 to $1,000 a month at most for covering those two costs. But I think that would be fair. That would put her in a position where she would have to show that she's really serious about this appeal, and I know she is, and has to make a substantial sacrifice. That would be a huge sacrifice for her, just even $1,000 a month, but that would at least give her an opportunity to exercise her rights.
Mr. Eaton, anything more you want to say to me?
Only that if you review the affidavit of indigency, she has approximately $1,900 available to pay for use and occupancy. And I think
No, she doesn't. She's only making, I'm sorry. Is that what it says? Maybe
That's
I'm
not what it says, but that's they added it wrong.
I think her calculation was a little off. She has $1,900 in available income otherwise, but she still has to live off of that. 1/3 of that is for housing.
Is this basically saying $400 a month?
That's what it says, but the arithmetic is incorrect.
I think she had made an error in the math, but it's she makes $31,000 a year. It's not arguable. I think her calculation when adding.
Oh, the 3,300 down to 1,388 is wrong.
That's where she messed up. Yes.
So the actual amount is $1,900 a month.
So $1,900 a month. I can agree that there was an error there. Yes. But it doesn't change much, if anything. That's
all right. Well, but no, that's helpful. I don't know. This is the most substantive appeal bond argument I've ever had, and I think I understand it. And I thank you both for your time.
Okay, thank you.